Hello viewers, today we will be discussing the topic of maternity leave. This lecture will help you to understand what is maternity leave, who are entitled to maternity leave, the constitutional provision on the concept of maternity leave, statute on the concept of maternity leave. We will be starting with the meaning of maternity leave. Maternity leave and parental leave is absolutely vital for strengthening families. It's an issue for men, women, and even baby in the womb and newborn baby. At present, in this competitive world, family may not be able to survive on one person, that is male earning. So, it has created an unavoided situation to women to participate in earning. And some women, because of their fashion towards their aims and aspiration, started to involve in earning works. At this juncture, a woman has to perform multitask. Here, the most important task that she has to perform and that only can be performed by a woman is bearing and giving birth to a child. Here it is proved fact that women involvement in work as well as to give birth both are necessary for continuation of this society. To provide health care to women and child by providing financial support to the mother, the concept of maternity leave and benefits or allowances to working women came into force. Parental leave or family leave is an employee benefit available in almost all the countries. The term parental leave generally includes maternity, paternity, and adoption leave. A distinction between maternity leave and parental leave is sometimes made. Maternity leave as a mother's leave time directly before and after childbirth, and parental leave being the time given to care for newborns. Parental leave has been available as a legal right or government program for many years in one form or another. In 2014, the International Labour Organization reviewed parental leave policies in 185 countries and territories and found that all countries except New Geneva have laws mandating some form of parental leave. Constitutional provisions. The Constitution of India not only grants equality to women but also empowers the state to adopt measures of positive discrimination in favor of women for neutralizing the cumulative socio-economic, education, and political disadvantages faced by them. Fundamental rights, among others, ensure equality before the law and equal protection of law prohibits discrimination against any citizen on grounds of religion, race, caste, sex, or place of birth and guarantee equality of opportunity to all citizens in matters relating to employment. Article 14, 15, Article 15 Clause 3, 16, 39A, 39B, 39C and Article 42 of the Constitution are of specific importance in this regard. Constitutional privileges. Equality before law for women. Article 14. The state shall not discriminate against any citizen on ground only of religion, race, caste, sex, place of birth or any of them. The state to make any special provision in favor of women and children under Article 15 Clause 3. Equality of opportunity for all citizens in matters relating to employment or appointment to any office under the state. Article 16. The state who directs its policy towards securing for men and women equally the right to an adequate means of livelihood. Article 39A. And equal pay for equal work for both men and women. Article 39D. To promote justice on a basis of equal opportunity and to provide free legal aid by suitable legislation or scheme or in any other way to ensure that opportunities for securing justice are not denied to any citizen by reason of economic or other disability. Article 39A. The state to make provisions for securing just and human conditions of work and for maternity relief, Article 42. The state to promote with special care the educational and economic interest of the weaker section of people and protect them from social injustice and all form of exploitation, Article 46. The state to raise the level of nutrition and the standard of living of its people, Article 47. Eligibility. As per Section 5 Clause 2 of the Act, to be eligible for a maternity leave, a woman must have been working as an employee in an establishment for a period of at least 80 days within the past 12 months and earned up to Rs 50,000 in wages. Payment during the leave period is based on the average daily wages for the period of actual absence. 10 weeks before the expected date of delivery, the woman may ask the employer to give her light work, and at that time, she should produce a certificate certifying she is pregnant. She should give a written notice to the employer about 7 weeks before the expected date of delivery that she will be absent on leave for 6 weeks before and after her delivery. She should also name the person to whom the payment will be made in cases she herself cannot take it. The Maternity Benefit Act applies to the women who cannot claim under Employees State Insurance Corporation for the reason of her income being above Rs 3,000 per month. Payment of wages. The payment is calculated at an average daily wage which is equivalent to period of 3 calendar months during her absence, that is maternity leave. In the event of women's death during the delivery or during the period immediately following the delivery wherein the child survives, the deceased woman is entitled to full maternity benefit for such period to the surviving child. Hence, the employer is liable to pay the full maternity benefit. In the event of a child's death at the time of delivery or any day after the delivery, the benefit has to be calculated till such period, including the date of death of the child. If the employer is not providing free medical care, then the employer has to pay a sum of 3,500 to the claimant. This is with effect from 19th December 2011. Maternity Benefit Act of 1961. It is an act to regulate the employment of women in certain establishment for certain period before and after childbirth and to provide for maternity benefit and certain other benefit. The Maternity Benefit Act 1961 protects the employment of women during the time of her maternity and entitles her of a maternity benefit, that is, full paid absence from work to take care for her child. The Act is applicable to all establishments employing 10 or more persons. The Act was applicable to all establishments which include factories, mines, plantation, government establishment, shops and establishment under the relevant applicable legislation or any other establishment as may be notified by the central government. In response, Ministry of Women and Child Development, Maneka Gandhi, had said that benefits for pregnant women will soon be expanded throughout the country. Gandhi has played significant role in pushing the issue. Her ministry had earlier proposed to increase maternity benefit to 8 months. The Maternity Benefit Act originally provided paternity benefits of 12 weeks, out of which up to 6 weeks could be claimed before delivery. In 2017, the law was amended to extend the period to 26 weeks. Out of the 26 weeks, up to 8 weeks can be claimed before delivery. However, the person concerned need not structure their leaves in this manner. They can instead take the entire 26 weeks of leave after the delivery. Also, these are maximum periods of claim and they can claim the benefit for a smaller period as well. Women undergoing a tuberculotomy operation also get a paid leave of 2 weeks following the operation. In case of miscarriage or medical termination of pregnancy, the law permits women 6 weeks leave after the procedure. In case of an illness after delivery, miscarriage, medical termination of pregnancy, or tuberculosis, a woman can claim a leave with wages for a further period of 1 month over and above what is allowed. Main object behind providing maternity benefit. The fundamental purpose for providing maternity benefit is to preserve the self-respect for motherliness, protected the health of women, complete safeguard of the child, etc. The objective of maternity benefit is to protect the dignity of motherhood by providing complete health care to the woman and her child when she is not able to perform her duty due to her health condition. There is a need for maternity benefit so that a woman is able to give quality time to her child without having a worry about whether she will lose her job and her source of income. The maternity leave and benefits are provided to protect the dignity of motherhood by providing for the full and healthy maintenance of women and her child when she is not working. As number of women employees is growing in India, maternity leave and other maternity benefits are becoming increasingly common. In 1961, the Maternity Benefit Act was passed by Indian government aiming at a uniform maternity benefit all over the country, with an aim to regulate the women employed in factories, shops or commercial establishments where 10 or more employees engaged. Because of so many international conventions like the Convention of Elimination of All Forms of Discrimination Against Women, the International Convention on Economic, Social and Cultural Rights, and the Universal Declaration of Human Rights, etc., International Labour Organization, contribution and several expert bodies like WHO have recommended that 24 weeks of maternity leave is required to protect maternal and child health. At the same time, with the national judicial pronouncement being passed from time to time, Indian government has been amending the Maternity Benefit Act to reform Maternity Benefit Act 1961. Maternity Benefit Bill 2016 was passed in Rajya Sabha on August 11, 2016, in Lok Sabha on March 9, 2017 and received an assent of President on March 27, 2017. The provision of the Maternity Amendment Act 2017 are effective from April 1, 2017. However, provision on crèche facility shall be effective from July 1, 2017. The main aim of the Act is to regulate the employment of women during the period of childbirth. It has amended the provision related to the duration and applicability of maternity leave and other facilities. Key features and implications of Maternity Benefit Act 2017. Applicability of the Act. As per Section 2 of the Act is applicable to all those women employed in factories, mines, and including every shops or commercial establishment employing 10 or more employees. As per this section, the original provision will prevail, that is, the Act is applicable to all women who are employed in any capacity directly or through any agency, that is either on contractual or a consultant. Protection from termination or dismissal during the pregnancy. Section 12 of the Maternity Benefit Act 1961 emphasizes that any dismissal or discharge of a woman during the pregnancy is unlawful and such employer can be punished under Section 12 of the Act. However, in case of gross misconduct, the employer can take necessary actions as per defined disciplinary procedure of the company. Duration of maternity leave in India. The Act has increased the duration of paid maternity leave to 26 weeks from the present 12 weeks. The extended period is applicable to women in cases of the first and second child. Women who are expecting after having 2 children, the duration of paid maternity leave shall be 12 weeks, that is 6 weeks pre-delivery and 6 weeks post-delivery. For adopting and commissioning mothers, the Act now extends to adoptive as well as the commissioning mothers. Every woman who has adopted a child will get 12 weeks of maternity leave from the date of adoption. Work from home. It also introduces the option of work from home for mothers. After the expiry of 26-week leave period, women can use their option to do her work from home. This option can be modified according to the nature of work and terms and conditions levied by the employer. Creches. The Act makes it compulsory for every establishment employing 50 or more women to have in-house creche facility and allow women to visit the facility 4 times during the day. But the age of the children up to which age are entitled to the facility of the creche is not mentioned in the Act. Awareness. The Act makes it compulsory for employer to aware women about the maternity benefit at the time of their appointment. Such information must be given in writing and electronically. Significance of the Amendment Act 2017. The Amendment Act has raised the maternity benefit from 12 weeks to 26 weeks. This is significant and is in line with the recommendation of World Health Organization, which says that children must be exclusively breastfed by a mother for the first 24 weeks. The extension in the maternity leave will help in improving survival rate of children and healthy development of both mother and child. This will also reduce the instances of women dropping out of the labor force due to absence of adequate maternity leave. The amended Act also falls in line with best international practices such as Maternity Protection Convention 2000, which calls for at least 14 weeks of mandatory maternity benefit. Another significant feature is the introduction of 12 weeks of maternity benefit to the adopting and commissioned mothers. The amended provisions have placed India third worldwide on behind Canada and Norway globally in the amount of maternity benefit being made available to the women worker. Some low light in the Amendment Act of 2017. This amendment promoting patriarchy. Many social scientists are of opinion that it will promote patriarchy as almost whole responsibility of child caring is on the mother as per this amendment. Government has not announced any leave for the fathers. Adverse impact on the job opportunity for women. Many private firms may avoid giving jobs to such women who may enter into pregnancy period, as then they have to give them maternity leave up to 26 weeks. The increase in the maternity leave could also have adverse impact on the job of opportunity for women. The requirement of full payment of wages during maternity leave could increase cost for the employer. It could result in increased preference for hiring male workers. The provision could also impact the competitiveness of industry that predominantly employ women workers. Lack of clarity. Various provisions of the amended Act lack clarity. For instance, there is no clarity in the Act regarding time period up to which the creche facility can be availed. Gender discrimination against women having childbearing age. Policy design is important and making such leave an employer mandate, as in India, ensure employer will discriminate against women of childbearing age. Additional requirements like creche facility require more capital and operating expenditure. It won't come as a surprise that some companies in India might shy away from hiring young women. When they do, the women might face a reduction in compensation as firms compensate for higher lifetime cost. Type of burden on the employer. Employers have to bear the entire cost of providing leave to the employees in terms of both continued pay while on leave as well as the indirect cost of having to get the work done by employing other workers to finish the work of the absent employee. Also, it increases the cost of temporary training provided to the employee which is employed on behalf of the absent employee. Women will lose their job. Regarding how the bulk of employment is in informal sector, team leads estimate that 11 to 18 lakhs job for women will be lost because of the implementation of the Act over the first 4 years. Financial burden only on the employer. In most countries, the cost of maternity leave is shared by the government and employer, insurance agency and other social security programs. In Singapore, for example, the employer bears the cost for 8 weeks and public fund for 8 weeks. In Australia and Canada, public funds bear the full cost. A social insurance scheme bears the cost in France. In Brazil, it is shared by the employer, employee and the government. Cost intensive. The measures introduced particularly the creche facility, are cost intensive and may deter employer from hiring or retaining pregnant women. A 2014 International Labour Organization report specifically cautions against making the employer solely liable for the cost of maternity benefit for this reason. The provision regarding the applicability of the Act to the unorganized sector also remain unclear. Though on one hand, the Act states that it covers all women working in mines, plantation, shop and establishment as well as factories in both organized and unorganized sector. But on the other hand, the Unorganized Worker Social Security Act 2008 defines unorganized sector worker as those who are home-based, self-employed or wage worker working in an entity having less than 10 employees. So, the provision did not clarify whether the Act is applicable to the women employees in those enterprises having less than 10 employees. This is disturbing as over 90% of the working women are employed in unorganized sector in India. Though the women working in unorganized sector can avail benefits from the schemes such as Janani Suraksha Yojana and Indira Gandhi Mateva Sahayog Yojana, they get their benefit only in terms of cash assistance and lack other institutional support provided in the Maternity Benefit Act. Another issue is that the amendment are silent on provisions regarding paternity benefit. At present, paternity benefits are permitted in government jobs as a part of leave rules and in private organization as a matter of internal policy. In this regard, ILO has recognized men's right to parenthood. It wants to see men as active co-parent. In a country where gender stereotypes are predominant, a gender-balanced approach to parenthood is needed. The government should come up with incentivized scheme regarding paternity benefit to achieve this objective. Do's and don'ts for the employer. The employer shall not engage the claimant in any heavy strenuous work and shall engage the claimant only in light work for 10 weeks before the date of expected delivery. The employer shall not during such period of leave or absence of the claimant reduce the daily wages of the claimant for the reasons for her absence or allocation of less stressful work, discharge or dismissal of the claimant for the reasons of her absence, or serve any notice of dismissal which will expire during her period of absence. However, the employer can do the above and can also deprive the maternity benefit in the event of gross misconduct committed by the claimant, and such discharge or dismissal notice shall be duly served to the claimant stating reasons the claimant is entitled to appeal to the appropriate authority within 60 days from the date of receipt of such notice for the relief. The unlawful discharge, dismissal of the claimant and non-payment of maternity by the employer attracts imprisonment not less than 3 months up to 1 year or fine not less than 2,000 or up to 5,000 or both. So we can conclude by saying that fundamental purpose for providing maternity benefit is to preserve the self-respect for motherliness, protect the health of the women, complete safety of the child, etc. The extension in the maternity leave will help in improving survival rates of the children and healthy development of both mother and child. We have also learnt about the Maternity Act and various loopholes in the Act. The main purpose of this lecture was to create awareness on the concept of maternity leave, which is available to the working women of our society. I hope the lecture is fruitful for you. Thank you and have a nice day.